Hi, everybody. It's Mike Kennedy, Vermont Bar Council. And I'm back today to try to use an old prop to get myself going again with the blog and doing some of these videos to help folks out with legal ethics and their professional responsibilities. So the old prop is the back to school metaphor. It's back to school season. I'm a little bit late on that because I still wasn't into blogging after Labor Day as I thought I would be, but I'm getting to it now. So back in the back to school construct, I like to think about, let's go back to the basics. What are some of the basics of legal ethics and professional responsibility? And, it can be rote to hear me say the same thing over and over and over again, but everybody who's heard me before or read the stuff on the blog before knows what I'm going to say the basics are. And those are the 5 C's, 7 C's of legal ethics. It's really 5. I've added 2 of my own. But those are the basics. And I think if you just remember the C's, 5 simple concepts, 1 word each which begins with the letter C, it'll go a long way towards the most important C, which is complying with your professional responsibilities. Let's do a quick overview of the C's. First, competence. Very first rule, a lawyer shall provide competent representation to their client. What does that mean? Know your job and do your job. It's that simple. That's competent representation. I think you can also make an argument that it includes complying with all of the other rules. For instance, competent representation includes conflict-free representation. Competent representation includes communicating with your clients. Competent representation includes safeguarding your client's property and their money. So yeah, those could be independent violations, but I think it also, all of it goes to the duty of competence. Remember, the duty of tech competence in comment 8 to rule 1.1, duty to understand the risks and benefits of relevant technology. That's always going to exist. So some of you are the most tech competent among us right now. You have to remain up to date on tech. The people, I said this at the law school in a presentation last week, some of the law students probably have roles, whether it's as an intern or summer job, whatever, in a law firm where they kind of laugh at how people my age might approach technology. Someday they're going to be the people my age. Technology is not going to stop between now and then. It is going to continue to evolve. So that's a continuing duty. Remember it. And also remember, most importantly, when it comes to competence, well-being is an aspect of competence now. Comment 9, the Supreme Court adopted it 2019. We have to take care of ourselves before we can take care of so that we can take care of our clients. On that, the most important part of the thing that I just said was most important is this: help's available. If you ask, help will be provided. Referrals will be made, and we will do so to the extent we can. And I will try so hard in a way that decouples help from the disciplinary process, and for you law students, in a way that decouples help from the admission process. So that's the first C, competence. The next, communication. Rule 1.4, duty to keep the client reasonably updated about the status of their matter. That's the essence of the duty. As like I always say, the key aspect to me of communication is to set and manage reasonable expectations at the start of the representation. Communicate to the client reasonable expectations about the result, about how long it's going to take to reach the result, about how much it's going to cost to get through the process, and about how often they're going to hear from you. I think if you communicate those things to the client, and then along the way, keep the client updated as to the status of their matter, that goes a long way towards satisfying the duty to communicate. And when you do that, the upfront part about setting reasonable expectations, not only does it go a long way towards satisfying the duty to communicate with the client, I think it goes a long way towards preventing the client from filing a complaint. So sure, the client might not be happy to learn what they should reasonably expect, but your job is not to make them happy. Your job is to provide them with candid legal advice. And if you look at Rule 2.1, the rule that talks about providing candid legal advice, there's language in the very first comment that says something to the effect that a lawyer should not be deterred from providing candid legal advice by the fact that the client will find it unpalatable. So yeah, a client might find your advice unpalatable, but in the end, There's nothing they can complain about. What they can complain about in the end, if you fail to communicate to them reasonable expectations, or if you choose not to deliver advice just because they might find it unpalatable, you will likely find yourself in a spot where the client doesn't get what they thought they were going to get from you. Maybe they never should have thought that they were going to get that, but they don't know that because you, as their lawyer, did not disabuse them of their unreasonable expectations. What do they do when they're not happy because they didn't get what they thought they were going to get? They look for ways to lash out, to assign blame. That could be the disciplinary complaint to the professional responsibility program. Okay, next, let's talk about confidentiality. You know my position on confidentiality. There's no reason to be talking about your client matters, none. If you don't talk about your client matters outside of your relationship with the client and outside of what you're supposed to be doing in the case, representing the client, you have no worries when it comes to violating the duty of confidentiality. There are 4 exceptions, of course, to when you can disclose information to the representation. First, client consents. Second, disclosure is impliedly necessary to carry out the representation. Third, disclosure is required in those instances. It's in Rule B of Rule 1.6, where, for instance, the client's going to commit a crime that's reasonably likely to result in the death of or substantially bodily harm to somebody else. Rarely happens. And then finally, the last exception, there's permissive disclosure under paragraph C to Rule 1.6, where a lawyer is permitted but not required to disclose otherwise confidential information. For an example there would be in response to a court order to disclose the information. You are permitted to comply with the court order. In response to a controversy between you and the client about your representation of the client, which could be a malpractice case, which could be a disciplinary complaint, which could be a petition for post-conviction relief, you are authorized to respond by disclosing information that is otherwise confidential. But remember, when it comes to client confidences, I think the best answer is, as my dad used to say, via a magnet that we had on our refrigerator, quote from Thomas Edison, something to the effect that as you go through life, you're going to have plenty of opportunities to keep your mouth shut. You should take advantage of them all. That, to me, is the same with client confidences. As you go through life, you're going to have plenty of opportunities not to disclose client confidences. You should take advantage of them all. Okay, conflicts. Conflicts, tough. Tough to define. What is a conflict of interest? Probably 50% of the inquiries I get each year involve conflicts. I try to tell a lawyer, no, I do tell lawyers, I don't try to tell them this, that conflict, a couple things. Trust your gut. If it feels like a conflict, feel like, you probably shouldn't be doing this, probably shouldn't take this case, probably should call Mike Kennedy to see what he thinks, go ahead and call me. But when you say all those probablys, you're probably right. It probably is a conflict. So I think trust your gut. If it feels like one, it might be. And I think when it comes to conflicts, it's best to not even get close to the line. I often tell lawyers, look, if you're not violating the rules, go ahead and do it, whatever it is. If you're not violating the rules, it's okay. Conflicts have a little bit of a different approach, which is sometimes just getting close to the line can be problematic. Not that it's going to result in something happening to your law license, but maybe it's a motion to disqualify you, which will delay, cause extra expense, the underlying resolution of the resolution of the underlying matter. So I think it's best to just sort of avoid those situations where your mere presence creates the appearance of a conflict of interest. That's not to say that the appearance violates the rules. I want to be clear about that, but I think it's an area where it's better safe than sorry. Also on conflicts, many of you have heard me say this before. Remember the sign, it's a road sign, where you come to a road that just ends, tees into another road, and there's a sign on the other side with an arrow pointing that way and an arrow pointing that way. That, to me, there's a sign. I see one all the time when I'm running. I come to that intersection. That represents a conflict in that if I'm supposed to be going this way, following that arrow to do my job for my client, but there's something pulling me this way in the direction of that arrow, whether it's another client, a former client, a personal interest of my own, anything pulling me opposite of where I'm supposed to be going for my client to provide my client with competent representation, probably a conflict of interest. Candor, the fifth C. Candor to a court is the most important rule. It's the one that where within the comments makes very clear that it will take precedence over all other rules, including in situations where complying with the duty of candor will result in grave consequences to the client. I don't know how many of you, I don't know that this is a frequent occurrence, but some of you have to deal with situations in which your clients provide opposing counsel or the courts, usually the court, with false evidence or false information. The rule goes through the steps to take when that happens. I'm not going to go through it right now. You can call me and I'll walk through it, but check out the comments to the rule on the duty of candor. The two C's that are not mentioned in the rules themselves, the first is commingling. Commingling does not appear as a word in the rules of professional conduct. It's captured within Rule 1.15, paragraph A, which talks about a lawyer shall keep the lawyer's property and funds separate from, a lawyer shall keep a client's property and funds separate from the lawyers. Don't keep your own money in your trust account. Okay, just don't. The Supreme Court has said in a series of decisions, that's a very serious violation. So serious, in fact, that we may start with a public reprimand, one that names you as the baseline sanction, even for what appear to be relatively minor instances of misconduct. You know, there is a level of sanction below that, an admonition, which does not identify a lawyer. There's a case from 2009, I think, where the Supreme Court said, look, commingling is so serious that we're going to treat public reprimand as the starting point. So get your own money out of there. The exception, of course, is paragraph, I think it's B or C, I can't remember which, to the same rule, which says that you can have your own money in the trust account, but only to the extent to cover reasonably expected bank charges and bank fees. So what does that mean? It means this: you got to sort of have a general understanding of what the bank's going to charge you, if anything, fees on the account. You can't just dump in $1,000. You know, we debated that when we passed this rule. What about, can we just put in $5,000, make it, any lawyer can have up to $5,000 of their own money in there? Well, no, because some lawyers don't have any bank fees or charges associated with their account. Others might have much more than $5,000, depending on how busy their practice is. So whatever the fees are that are regularly charged to your account, you can deposit your own money in there to cover those reasonably expected fees. Otherwise, don't commingle. And then the final C, civility. Doesn't appear in the rules of professional conduct. I've spoken of it often. You can do your job. We can do our jobs as lawyers. We can provide competent, diligent, even zealous representation. Zealous no longer in the rules. It's in the comments, not in the rules. Without being jerks, without being, probably shouldn't swear in this video, but we can do it. There's nothing inconsistent with competence and diligence and civility. I have several posts on this. I also think it's important to remember that the lack of civility, to the extent it's increasing or has increased during the pandemic, is causing stress and anxiety among other members of the, so my incivility, constant, to people who are on the other side of cases, affects them and affects their wellness. And we have situations right now where certain aspects of the practice of law have become so frequently incivil that people within those areas are looking to get out either of those areas or of the practice of law altogether. So I think we need to continue to try to focus on doing our jobs without being jerks. So those are the 7 C's. Again, I think, it's easier to remember the C's than it is to try to remember the rules. But that's the sort of overview. And as we go through this school year, so to speak, this is not just an overview, but it's kind of the syllabus, because everything I'm going to be talking about, posting about, doing videos about for the next several months will be one of the 7 C's, because to me, everything about professional responsibility and legal ethics falls under the heading of the 7 C's of legal ethics. Thanks for listening, and welcome back. Hope you had a good summer.